Expert witness. Explain. Disclosure of such a fee arrangement would likely render the expert's opinion inadmissible. ANS. The statement refers to the potential impact of disclosing a fee arrangement between an expert witness and one of the parties in a legal case. In many legal systems, an expert witness is hired to provide specialized knowledge or opinions that may help a judge or jury understand complex issues. However, for the expert's opinion to be admissible, accepted as evidence, in court, the expert's credibility and impartiality must be unquestioned. If it's revealed that the expert is being paid in a way that suggests bias, for example, if their payment depends on the outcome of the case or if the amount of the fee is unusually high, it could raise concerns about the fairness and objectivity of their opinion. The disclosure of such a fee arrangement, like a performance-based or contingent fee, could cause the judge to question whether the expert's opinion is truly independent or influenced by the party paying them. This could lead the judge to exclude the expert's testimony from the case, making it inadmissible, not allowed as evidence. In short, if there is a conflict of interest suggested by the fee arrangement, it could undermine the expert's credibility, potentially resulting in the court rejecting their opinion as evidence. Explain. If the opinion is unfavorable, the client might be better off settling the case in its early stages, rather than incurring substantial legal and expert fees pursuing a losing cause. ANS. The statement suggests that if an expert opinion or evidence is unfavorable to a party in a legal case, the party might consider settling the case early rather than continuing to fight it in court. Here's why. 1. Unfavorable expert opinion. In many cases, expert witnesses provide specialized opinions that can significantly influence the outcome of a case. If the expert's opinion is damaging to the party's position, it may suggest that the case is unlikely to succeed in court. 2. Cost of litigation. Legal proceedings, especially complex ones, can become expensive. Costs include attorney fees, court fees, and potentially expert witness fees. If the case is heading toward a loss, continuing to spend money on these costs may not be a good financial decision. 3. Settling early. Rather than going through lengthy and expensive litigation, the party might find it more advantageous to settle the case. A settlement is an agreement between the parties to resolve the dispute without a trial. Settling early can save on costs, reduce uncertainty, and allow the party to avoid the risk of a potentially larger financial loss if the case goes to trial and results in a verdict against them. In summary, the statement highlights a strategic decision-making process. If the evidence or expert opinion is unfavorable, it might be more financially prudent for the client to settle early and avoid the escalating costs of pursuing a losing case. MCQ 1. Why is it not in a client's best interest for an expert witness to provide a weak or biased opinion? A. Because it will automatically lead to a favorable verdict. B. Because the expert will not be cross-examined. C. Because the opinion will not stand up to scrutiny and may be exposed under cross-examination. D. Because courts do not allow expert witnesses to testify. Answer: C. Because the opinion will not stand up to scrutiny and may be exposed under cross-examination. 2. How can an expert witness best serve the client's interest? A. By providing an honestly held opinion, even if it is unfavorable. B. By tailoring their opinion to support the client's case at all costs. C. By avoiding testifying in court. D. By refusing to answer questions during cross-examination. Answer: A. By providing an honestly held opinion, even if it is unfavorable. 3. What might be the best course of action if an expert's opinion is unfavorable to the client? A. To proceed with the case regardless of costs. B. To suppress the expert's findings. C. To consider settling the case early to avoid legal and expert fees. D. To find another expert who will provide a more favorable opinion. Answer: C. To consider settling the case early to avoid legal and expert fees. 4. What is a key responsibility of an expert witness in cases involving professional negligence? A. To act as an advocate for the party who hired them. B. To prove the plaintiff's case beyond a reasonable doubt. C. To testify about the standard of care expected of a competent professional in the field. D. To determine the final verdict in the case. Answer: C. To testify about the standard of care expected of a competent professional in the field. 5. What is the primary role of an expert witness in court? A. To assist the court in understanding technical and professional matters. B. To ensure the client wins the case. C. To provide legal advice to the judge. D. To make final decisions on liability. Answer: A. To assist the court in understanding technical and professional matters. 6. Why are expert witnesses prohibited from charging contingent fees? A. Because they are only allowed to work for free. B. Because contingent fees could create a conflict of interest and compromise objectivity. C. Because courts do not allow experts to charge fees. D. Because expert testimony is always voluntary. Answer: B. Because contingent fees could create a conflict of interest and compromise objectivity. 7. What must a plaintiff prove in a civil case involving professional negligence? A. That the defendant failed to meet the required standard of care on a balance of probabilities. B. That the defendant intended to cause harm. C. That the defendant was criminally liable. D. That the expert witness is biased. Answer: A. That the defendant failed to meet the required standard of care on a balance of probabilities.